case number 23-1866, Eglin Federal Credit Union versus Bard, Stokes Wilkinson, and others individually and on behalf of others similarly situated. Appellant's counsel, when you're ready.
Thank you, Your Honor. May it please the Court, James Brannett for Eglin Federal Credit Union. Your Honors, I'd like to make basically 4 points during our oral argument. Anything not addressed here today, we rest on our brief. But first, there was a reasonable notice of the terms of the offer. In fact, for the plaintiff Stokes, it's deemed under Florida law that she had actual knowledge of every word in that arbitration agreement. She had actual knowledge that she needed to opt out in order to avoid being required to arbitrate any disputes. Consequently, her failure to opt out constitutes conduct. Not just her failure to opt out, but her actual continued use of that account constitutes, given her knowledge that Eglin was going to perceive her conduct, her continued use, as an objective manifestation of her assent. Her continued use of that account, every time she wrote a check, every time she went in and interacted and transacted, that constituted an objective manifestation of assent.
Mr. Brandt, real quickly, would you like to reserve some time for rebuttal?
I'm sorry, you're right. I did reserve 2 minutes for rebuttal.
Very good, thank you.
The third point I'd like to make is that the scope of the arbitration clause is a question for the arbitrator. It was not a question for the court. Even if it was a question for the court misinterpreted the provision that applies here defining claims. Any and all claims, period. That's what is subject to arbitration. The fourth point, if I get to it, is that the class action waiver is not unenforceable, and in fact, the enforceability of it was never at issue. The trial court engaged in circular reasoning by saying that because there was no agreement to arbitrate, that means the class action waiver is unenforceable. Well, if there was no agreement to arbitrate, then that poison pill provision that the trial court was relying on didn't exist either. So you can't use that to destroy the arbitration clause. The fundamental question is, did they agree to arbitrate the case? So here are the undisputed facts. Eglin mailed in the notice and the arbitration provision to Stokes. It's undisputed that she received it. She offered no evidence in conflict with that. She contractually agreed under the terms of the contract that she received effective notice as soon as we put it in the mail. That's freedom of contract. She could have, the bottom line is that she agreed by contract that was effective notice to her. Even under the mailbox rule, setting aside the term of the contract, she's presumed to have received that document because we sent it to her address. Consequently, under the law, she was required to rebut that with some evidence. She offered no evidence whatsoever. So it's undisputed here that she received it. She had this mailing and the notice and the arbitration provisions in her hand. Not only that, but under the law, as a reasonable person, she had a duty to actually read it. She had it in her hands, and she's deemed to have actual knowledge of the entire content of that notice and the arbitration provision and the opt-out document at the very end of it. This is a 4-page document, Your Honors. There's no question that she had a duty. A reasonable person would look at all 4 pages. So consequently, the trial court's assertion here that somehow the cover letter threw her off does not address the law that she had the ability, and a reasonable person would actually move on to the very next page after the cover letter and take a look at what they were doing.
Now, Mr. Brannett, we're dealing with a class action complaint, 2 individuals named. You've just talked about Ms. Stokes.
Right.
Are we dealing with a case here where the facts are materially different for purposes of the contracting aspects and going through offer acceptance, what have you, mutuality, where we have 2 individuals that are in different places?
Yes, I mean, it is an individual question. You have to apply the analysis to both plaintiffs individually. And I will get to Beard because her facts are different, and I understand they're a little bit more problematic, but they still, in the end, under the law, Beard had constructive notice, and consequently she's also deemed to have actual knowledge of the contents of that, and that's important on terms of the assent. All right, so, but here's the key. The trial courts didn't dispute that Stokes had this in her hand. The trial court did not dispute the law that she's deemed to have actual knowledge of its contents. Instead, the trial court asserted a few things that are actually factual misstatements. And it's an illustration of the reason why trial courts should not just adopt whole hog and verbatim a draft order prepared by one of the litigants here. Because in that draft order that the plaintiffs prepared and the court just signed, there are several misstatements in there. The first is this idea that there was no mention of any change of terms. No indication that this notice relates to the count terms. Well, that's not correct, Your Honors. That the notice letter at the front specifically says we're adding an arbitration provision. That it relates to the account terms. It also constitutes an update to the membership agreement. So the trial court statement that there was no mention of any updates in that cover letter is wrong.
Well, let's assume we get past all of the notice, assent, all of that. What do you do with the trial court's conclusion that the arbitration clause did not apply to accrued claims, and all of the reasoning on page 8 of its order and forward?
Your Honor, yeah. I'm hoping you have in front of you the actual language there, because that's important to look at it specifically. What this says, it applies to all claims, is the arbitration requirement. It starts out, the claim means any claim or dispute. That's the global scope of this. Any claim. Is it a claim arising out of past claims? If it is, yes, that's any claim. If it's a claim arising out of future events, yes, that's a claim. It's covered. It's any claims or disputes. Then there's a comma. It says whether arising in law, equity, or otherwise. Okay? That phrase really doesn't add any change to the scope of this at all. It's saying whether or not, whatever kind of claim or theory that you're asserting, all claims are still covered, any and all claims. And there's a comma. And regardless of the type of release sought, involving your deposit account relationships, loans, then, okay, so regardless means it doesn't matter.
Right, and I think we all have the language in front of us. I think one of the things that Judge Terrell found compelling was the federal court decision dealing with a similar type of clause and determining whether it was forward-looking as to the current agreement as amended by the arbitration clause, or did it encompass claims that arose under a prior agreement? Why was his reliance on that decision misplaced, if you believe it so?
Your Honor, his finding was based on his interpretation of the word obtains only, obtained rather than obtained. There's a second aspect that I'll get to in a second, but that was his first one, that obtains means in the future rather than also including in the past. The problem with that is twofold. One is this phrase regardless of means it really doesn't matter. We're just saying to you, no matter how you raise this, no matter what account or what relationship you're talking about, any claims are covered, period. So the regardless term in there is key. The second thing is, even if you read that, regardless of the type of relief sought involving your deposit account relationships, loans, and then there's a parenthetical, comma, all right? So that under common English usage, the following is a separate phrase, and you have to go back to figure out what it applies to. So it applies to regardless of the type of relief sought involving your or any other product. So it should read regardless of the type of relief sought involving any other product or scope. So that phrase after the comma does not serve to modify your deposit account relationships with us. Well, that's what the scope of this is all about, is our account relationship with these particular plaintiffs, period.
How do you distinguish our decision in All South dealing with a very similar arbitration issue and saying that it can't apply retroactively?
Your Honor, there's, well, that's the second aspect of the court, is that if applied retroactively, you should have specifically mentioned that. But that's actually according to the US Supreme Court, in order to exclude claims from arbitration, you have to expressly exclude them. You do not have to expressly.
So you disagree, or do you think we got it wrong in All South then?
No, I think there was different language involved in that rather than this. This is the first time I've seen this type of specific language defining this. And consequently, the phrase, any claims or disputes, any is what includes past and future. Okay? I don't think that was the specific phrase involved in Old South. The other point that I wanted to make is to go back to assent. Well, let me just make one more point, which is that under this very provision, the application of it, the scope of this arbitration requirement is to be determined in arbitration. It shouldn't have been determined by the court. The only question before that court was there an agreement to arbitrate? So it should have limited its analysis to offer and acceptance. I've already talked about the offer. What I want to address quickly is the acceptance. Okay, so the trial court's ruling on acceptance is based on silence does not equal assent. That's the wrong analysis. Again, we're not talking about silence here. We're talking about conduct. Remember, as to these particular plaintiffs, they are deemed under the law to have actual knowledge of the full contents of this. So they knew that they had, in order to opt out of this, they needed to say, I'm opting out. Otherwise, they knew that we were going to be interpreting their very conduct as acceptance.
So, and that would be any conduct, any deposit, any withdrawal, any accrual of interest? Would that be enough?
Continued use of the account. So, and she wrote checks, she used her accounts, she engaged in us through the website every day.
Okay, and so would it be different with a customer who was passive during, the relevant period? Let's say someone who just is accruing interest, doesn't make any withdrawals, doesn't, make any deposits. Is that a different, I know that's not your case, but there may be consumers in that kind of bucket as well. What about them?
Your Honor, in that circumstance, I would suggest that even having the account is using it. But here, another important part of this is that there are two aspects of this. One is knowing that Eglin's going to interpret my continued use of this account as an objective manifestation of my assent. Eglin has given me the opportunity to objectively manifest my rejection by sending them an opt-out.
So these people carry on in their ordinary course of business. There's no indication that they've done anything. There's no, they're just going about their ordinary lives. They're either making deposits or they're not. They're withdrawing money. They're carrying on business as usual. There's nothing to indicate that they know about anything or that they're agreeing to anything. And so in that sense, I think the trial court is interpreting that to say these people haven't done anything. This is equivalent to silence. There's been no change or indication of any kind of assent to the assuming notice, even assuming notice.
Well, 2 points. One is, yes, there has been an indication. As long as they have actual knowledge that their continued use, whatever they're doing with it, constitutes assent. We can define the terms of acceptance under the law. That's standard Hornbook law. And we did, and we said, you continue to use it, that's assent to us. And so they know that every time they write a check, every time they go to an ATM, that they're manifesting their assent to us. So it's not just silence, it's not just inaction, it's active conduct. The second point is that we've given them another option, which is to send us an opt-out. And under the Cornell opinion from the Arizona Supreme Court and the restatement of consumer contracts, that is a legitimate way to allow us to force consumers, which is the restatement of consumer contracts, to objectively manifest their intent to not be bound. Okay? Instead of a ink signature constituting a manifest intent to be bound, they are required to give us an objective manifestation of intent to not be bound by giving us an opt-out. So that's an alternative, but they perform both alternatives here in this case. Unless you have some questions.
Yeah, let me add 3 minutes to each side. Marshall, and you can use it now or use it on rebuttal,
Okay.
but go ahead.
Well, that's the key point here, is if you look at the restatement consumer of contracts, I spent days looking at that thing. The growing majority, the growing consensus is that it is very legitimate to allow merchants in particular who are engaging with consumers in this kind of contract, where we both can part ways at any time we want to, that when we give them notice of a change, that's effective notice, and all they need to do to avoid being bound by that new term that we've added, whether it's part of the contract or not, to be able to add it.
Is it right that neither our court or the Florida Supreme Court has really weighed in on this issue?
Yes, this is definitely, for this court and Florida in general, this is an issue of first impression.
And
Yes.
so your suggestion is that we adopt what you are characterizing as the growing consensus in the law in this area?
We definitely believe that the analysis in Cornell and in the restatement of consumer contracts has been well considered by the entire bar, by everybody involved in that process, just like the restatement of contracts was 50 years ago. And we would ask you to adopt that approach. I'd like to reserve the remaining time for rebuttal, if I may. Thank you.
Thank you, Ms. Brandt.
Good morning, Your Honors. My name is Sean Judge, and on behalf of the plaintiffs and appellees, I'm joined today at council table by Stephen Exter and Robert Price, my co-counsel. We're here today to defend the trial court's denial of the motion to compel arbitration below. And I think the overarching point to start with is that this is a case that demands attention to detail and nuance. As in reading the briefs last night again and looking through the transcript and listening to my brother present his argument, they're very articulate and they make it sound good until you look at the details of what was actually done. And then the argument starts to crumble very, very quickly. They suggested 4 points to you. You heard very little about Baird. We'll talk about Baird if we have time. There's a reason you didn't hear a lot about Baird. If you don't tell someone you're making an offer and you don't give them a chance to accept or not, it's really not an offer, and it's really not a contract change. So they've ran around away from Baird. They focused mainly on Stokes Wilkinson today. And I'll start with her. Eglin posits that there was a reasonable notice for Stokes here that she had actual knowledge of the contract changes. And they point to the letter and say, regardless of what our cover letter said, she should have read the rest of the pages and understood it. If you look at the actual contract, the amendment that was sent to her, as well as the cover letter is at page A163 in the record. It's not clear at all. It says we're adding 2 terms, an arbitration provision and a class action waiver with this mailing. The last sentence of the second paragraph says if you agree to these changes, your continued use of the Eglin Federal Credit Union account will act as your consent. Well, as the judge noted, most people do nothing. They did nothing here. Here Baird filed a lawsuit. But this letter went out on December 31st. The changes took effect on January 1st, 2022. There was no time to consult with an attorney, as the Chief Strategy Officer, Kathy Staton, admitted in her deposition. She said there was no time to consult with an attorney before the changes took effect and the class action waiver took effect. The class action waiver matters because there is the poison pill provision in section 40M.
Do you think the timing is really a critical point? I mean, if the letter had gone out, say, a month earlier, would that really change the analysis here?
I think it changes part of the analysis, but not all, because I think the changes here fail for at least 2 reasons. On one track, separate from the others, is the poison pill provision. You can't give someone no time to reject or opt out of a change. The class action waiver you can't opt out of. You're stuck with it the minute it becomes effective. And then the contract says, well, if that's struck down, it's unenforceable. The arbitration provision is unenforceable and goes away with it. So they gave someone no time to opt out. By the time they got the letter, it was over. They were already embroiled in the class action waiver applying to them. and then we can debate what claims mean, you know, whether it's retroactive or not. But, so those customers who received the letter were already under the new terms for the waiver by then, and that's unconscionable.
And the February 1 opt-out is sort of a nullity in your view, that didn't have any effect?
Well, you can opt out of the arbitration provision, but not the class action waiver. And the problem is, you know, under Florida law, for an offer to be a valid offer of valid communication, it can't be a unilateral modification. Their timing issue, they made it a unilateral modification. By the time they told you we're changing your terms, the terms have already been changed, and there was no ability to opt out. So I think that matters. You know, Ms. Statton at her depot admitted that, yeah, they could not opt out of the class action waiver. It said 168 in the record and 481 in the record. And
But that's really an independent argument, right? I mean,
it's an
the
independent, it's a
timing-
separate argument from that the notice wasn't reasonable and there was no agreement here.
Right, so even if you assume it's proper notice and acceptance and all of that, you have this kind of independent argument about the timing and that they didn't receive notice in time.
It's absolutely
to
correct.
meaningfully opt out.
Yeah, because I mean, the notice problem, they have a lot of problems with notice. For Stokes Wilkinson, the notice here was this letter, and they lay out, we've changed 2 terms. If you're agreeable to these terms, do nothing. Well, which would imply if you're not agreeable to these terms, what do? You read the 4 pages, and it never tells you how to get out of the class action waiver because you can't. So if you disagree with these terms, tough. If you disagree with the arbitration, then you could opt out. And what do? They make it very difficult to opt out. You have to go before a notary, or you have to go before an Eglin employee and sign a wet signature to opt out. You then have to take that signature either in person to the Eglin location here in this county, or you have to mail it to them. But during her deposition, Kathy Statton said, well, that's not right. We would have taken them by email. We would have accepted them in any branch. And the question was, well, does the letter say that? Does the materials you sent the people say that? She says, well, no, it doesn't. So they're putting onerous burdens that are not necessary and are unduly restrictive on the customers. So the average customer...
But because it's maybe difficult, does that mean, how does that fit into the analysis of offer and acceptance? I mean, just because maybe you gotta jump through some hoops, does that mean it's not a valid contract then?
In order to be a valid contract, you can't have silence equal acceptance other than very limited circumstances. One of which is that there has to be evidence that appellees intended their silence to equal acceptance.
But we're not talking about silence. I mean, and there's a third option, right? That the consumer who doesn't like the terms, in many cases, I know not all, maybe able to walk away, right? And go to a different bank. So when a bank, let's kind of start with kind of plain banking and contract law. So if the bank says we're going to change our insufficient funds fee from $25 to $100, and here's your notice, you have 30 days. If a consumer continues to use their checking account and bounces the check, right? At that point, that conduct, right, is assent, is it not? I mean, why is that analysis different here simply because we have an arbitration clause involved in the amendment?
For 2 reasons, one of which I think the arbitration clause here, and there's not just the arbitration clause, there's the class action waiver. Class action waiver, you can't get out of. You're already in it by the time you've been told about it, which is a serious problem.
But let's just take take one new term at a time. Let's take the arbitration term, right? So, and let's compare that to the insufficient funds fee that the bank unilaterally says we're gonna raise the rates, and if you want to continue banking here, great. But if you do continue banking here, you're going to be subject to that fee. As to the arbitration clause and the notice provided here, why wasn't that sufficient?
What courts have generally frowned upon is, we talk in the briefing about there's no objective manifestation of assent. There's no indication by the appellees that they intended that their silence equal assent. Just because the bank says, we're going to construe your silence or we're going to construe any inaction as assent, doesn't mean it's reasonable to do so.
But we're not talking about silence. We're talking about continuing to use an account. That's not exactly the same. I mean, I think we can agree that a passive user of the account who's simply accruing interest or paying interest may not be
I could see how you could parse it that way, and I would argue perhaps it should be. That's not what Eglin just told you. They said that the passive user who's doing nothing would still be under it.
Understood.
Yeah.
But as to the plaintiffs here, why, they're not just the passive users, you'd agree with that?
They're not just passive users, one of whom filed the lawsuit. The other of whom, joined that lawsuit and did not pursue the opt-out procedures. They were unduly burdensome. You can impose unduly burdensome restrictions and then say, if you don't meet our selective criteria, then you've agreed to it. If they told somebody that, you have to swim across the Gulf here in order to opt out, and they couldn't do it, you can't say, well, you've agreed to acceptance. It doesn't make sense to make them jump through hoops that they don't need to. Well, it's their burden to prove that the silence or just inaction equaled an intent, a mutual meeting of the minds to convey that, I am agreeing to these changed in terms.
Can you speak to the retroactivity of the arbitration?
Yeah, the retroactivity, I mean, there is no retroactivity. There has to be an express indication of retroactive application in order for it to exist here. The cases that we cite on pages, I believe, 41, 42 of our brief, talk about that there's a presumption against retroactivity. It has to be expressed. Section 40D of the agreement, we looked at, the use of the word or and obtain. Obtain is present or future tense. It's not past tense. So if they could have and should have, if they wanted this to cover existing claims, especially if they were going to screw around with the timing as they did and not give people a chance to opt out of the class action waiver and otherwise, they should have said any claims or services obtained or that you obtained. They did not. They just said obtain. Words matter. Words matter in a contract especially. And so we're stuck with future tense and present tense, but not for past claims. Because you end up with people like the customers here who don't want to be bound by these terms, who want to take action to avoid them, but they're stuck with them because they became effective because they got late notice.
What's your take on our decision in All South and whether it relates to?
I think it relates to contract language is different, but the overall overarching principle is the same. So I think by analogy it would apply here. There has to be some express indicator of intent to be retroactive. Just as a matter of simple fundamental fairness and logic and common sense, you can't impose something unilaterally, make it retroactive, and bind someone unless there was a mutual meeting of the minds. There's no indication here whatsoever. There was no indication in the All South case that there was any kind of intent to be retroactive. So I think the case, by analogy, this case would be an extension, would be a progeny of All South.
And whatever we think of assent, is the lack of reasonable notice alone enough to affirm the trial court's judgment here?
Yes, I think so. I mean, the lack of reasonable notice for Stokes Wilkinson, she received a letter that was ambiguous and complicated. The lack of notice to Baird was even more egregious. There were 2 emails sent after all these terms went into effect. Those emails included a hyperlink which directed her to a newsletter, and the newsletter contained just a simple little item. If you look in the record at A10, 110, it's just a little box. It says, important notice, we've changed added terms to your agreement. If you'd like a copy, stop by a branch, email us, or call us. Previously, incidentally, in the record and in the Stanton deposition, we talked about in 2018 and 2020, when they changed terms, they provided a description or summary in the newsletter of the changed terms. So they provided a hyperlink and information that would take you to those terms. They didn't do that here. When asked why, she said, I don't know, I didn't think it was important that we needed to do that here. So conspicuously, the only way to get to the newsletter is to go through a hyperlink that doesn't say there's an offer. The hyperlink takes you to a newsletter. The newsletter doesn't say there's an offer that you need to agree to or reject, or that there's an opt-out procedure. All the newsletter says is that there are new terms. Not a new offer, not a potential opt-out, simply new terms. and then it tells you you have to go find those terms.
Let's set Baird down for a second and return for a second to Stokes. So let's say hypothetically we think that there was sufficient offer and acceptance with Stokes, but that the arbitration provision can't be applied retroactively. Where does that leave us with regard to the class action waiver and its relationship?
Where does that, in regards to the class action?
What should we
waiver-
do with the class action under that scenario? What should we then do with the class action waiver?
I think the class action waiver, as mentioned, still falls apart for poison pill provision. Putting that aside, you would end up with just a change in class definition and a change in the class period. Because the retroactivity, you could argue that it started at this point and goes forward, so that would cut off some of the potential damages. But for any conduct that existed up to that point and going backward, that would be the class period for people like Stokes. It doesn't defeat the class action, but it defeats the period in which, how you would define the class and the period in which you would look at for damages.
Which is the claims we're talking about here.
Yeah. You know, we spent some time listening to opposing counsel talk about the definition of claim and what those words mean. And in their briefing, one thing I want to mention is that there was no meaningful opportunity to consider the arbitration offer here. They rely in their briefing, it's sort of odd briefing, they say we're not really relying on, but then they present an argument on how the change in terms clause affects this. And they said, well, we're not really changing our terms, and that the trial court got it wrong when they said they were ambiguous. The trial court applied the alter or amend language and found that that meaning applied to change meant that the contract was ambiguous and therefore construed against Eglin as the drafter. I sort of enjoy that a counsel in the briefing and today indicated that the trial court just signed a prepared order prepared by me, as if I was so persuasive I overcame the will of the independent trial court below. What the judge did is agreed with all our arguments, directed me as a matter of law, go forth, submit a proposed order that he would then consider, reject, modify, whatever. If I'm that persuasive, today should be a good day for me, but I don't think I'm that persuasive, unfortunately, to overcome your will as well. So I urge you not to discount the analysis of that order, the analysis of our brief, because the analysis holds up regardless of who prepared the order. The scrivener of the order is immaterial. And the definition the trial court correctly applied is change means alter or amend. The change in terms provision that gives them the power to change terms mean they can amend a term, they can alter a term, but they cannot introduce a brazenly new term, such as is done here with the class action waiver and what was done with the arbitration clause. Those are terms that have no analogous counterpart in the prior contracts. So it's not a change in terms, it's something wholesale cut out of cloth. If there are no other questions, I would ask that the court affirm on the basis of the reasoning set forth in our brief and adopted by the trial court below. And thank you for your time.
Thank you, Mr. George.
I'll apologize in advance for speaking fast. The first argument that they make that I want to address is this idea that the new term was effective January 1st, but you have 30 days to opt out. If we're sitting on a bus and the driver says, well, effective immediately, I'm changing the plan. We're not going to Panama City, we're going to Mary Esther. But I'll give you 3 minutes to get off the bus. Where are you going? Panama City or Mary Esther? It depends on whether you get off the bus. You're not bound by the fact that basically Eglin was saying, we're all agreeing to add an arbitration provision. If you want to come along, you can. If you don't have to. You can reject it. You can opt out. There's two different issues here. Are we going to be bound by it, or when does it become effective? It doesn't become effective until you agree to it. If you reject it, it never became effective. So there's no confusion there. We did not eliminate the ability for people to opt out by just saying that it became effective on an earlier date. Second, they talk about having to use a notary or witness by an employee. That's a common standard term by Eglin with all of its members, okay? To become a member, to open an account, you have to sign the membership application in front of a notary or one of their employees. So they know going in that that's a condition for signing things with Eglin. What our witness said during a deposition is irrelevant. This is for this court based on the terms, in the notice, the arbitration provision, the contract terms, to decide what those things mean, not the witness. All right, I don't mean to disavow my own witness, but the bottom line is that it all matters as to whether the terms, not whatever she said behind the scenes, because she didn't talk to all of our members. These documents did. Fourth, counsel admitted in terms of retroactivity that words matter. Well, that's why any claims or disputes matters. That is the express statement that this applies to all claims, any and all claims, past, present, or future. You can't ignore that phrase. Whereas with the whether, W-H-E-T-H-E-R, and the regardless, you can ignore essentially the rest of it, which is just reiterating that this applies to all claims, any and all claims. Fourth, in terms of the newsletter, as far as Beard is concerned, she had 30 years of experience with us, where she routinely understood that we sent these newsletters when we added new terms or changed terms. On top of that, it's undisputed that she got this notice by email. She was obligated to under the contract specifically told her, you have to examine your account statements as soon as you get them. So the email with the link to that, she had to click on. All right, she had a contractual obligation to do that. So she became aware of everything that she could have discovered by clicking on that link, including the terms of the offer. I'm sorry, I just realized it was counting up. I
Your time has
apologize.
expired, yes, Mr. Brown. So,
Thank you, Your Honor.
thank you. All right, that is, this is our last argument for this morning, so we are adjourned.